We're going to be discussing contracts today, both cash and creative, the things that you need to know to protect yourself and how to actually present this to your potential clients or your potential leads to get the deals done. The more confident you can be, like the biggest part about this training in particular is not just the verbiage and the contracts and all that stuff, but like this is typically the biggest point of apprehension when you're working with a prospect. So if you can present it confidently, that confidence exudes to the person across the table. So if you don't know what you're talking about, you can lose a lot of trust when it comes to actually getting the contract. So hopefully today you guys can understand all the pieces that you need and just practice going over this because it's going to be important when it comes actually with contracting deals. So the first thing I'm going to start with is our cash contract. This one is very basic. As you can see, it is literally 3 pages. Okay. And just for you guys being here today, I'm going to take the template of this contract and put it into this recording. So you'll have this contract to move forward with. I can't do that with a creative contract because it's not mine to sell. That's one that I had purchased from an attorney and I don't have resale rights to like pass that out. But this one I definitely do. So just for you guys being here today, you will get this template. This is the one that I use for all cash purchases. And the fun thing that's happening right now is we're doing a lot of cash purchases. So you're going to use this contract pretty often. So we'll start from the top. The most important stuff that you're going to fill out is going to be obviously the property information. There's 2 different pieces here. Okay, you have the actual address, the mailing address of the seller, and then the actual property that you're looking to purchase. Okay, your closing date's put here, and I'll say it's pretty normal with your cash transactions. A few things. You want to keep your earnest money as low as possible. This is a fake number. The seller will never ever see this, but it's important because you do have to pay your earnest money. Don't put $1,000. Don't put $2,000. Don't put $3,000. Pretty standard for us is about $500 for earnest money. Okay, so I'm going to tell you, I'm going to talk about first how we pre-fill out this contract, and then I'm going to teach you how I actually present this to the seller. Okay, and in a lot of our cases, if you guys follow along what we're doing, we actually present this to our real estate agents because we can't fill out a traditional purchase contract for whatever state we're in because we're not licensed to do so. So they have to do that if they want it. So normally we present it on just a contract like this, and we can present nationwide. So this is important. This agreement here, you guys can use in any state. Okay. So next thing, outside of the purchase price, sometimes, okay, this is important, your purchase price can also be see additional terms because very often, right? Because right here, just like what Shara is talking about, will this work for foreclosure as well? 100%. This is the same contract we use to purchase our foreclosure deals. But oftentimes with foreclosure deals, when we go and negotiate the deal, it's more along the lines of how much would the seller walk away with, right? So sometimes it's not a fixed price. And this is what I actually recommend doing oftentimes if you're working direct to seller, where someone is stuck on, I need $200,000. Well, $200,000 is just a pie in the sky idea of a number. Why is $200,000 significant? Let's work it backward. Okay, well, what are you guys hoping? So what's the plan? Do you sell this place? Are you guys going to be buying another place? Are you going to be moving something more temporary until you buy something else? Are you trying to take all your money here and buy your next house? What's the game plan so we can realistically come up with a win-win scenario? And what you'll often find is that number is just a starting point, and that's not what they're actually expecting. They have a number in their mind that they love to walk away with. So let's just say, if they're trying to sell that house for $200,000 or they're in foreclosure and they owe 110, I will focus more on, well, what do you guys want to walk away with here? If I could stop the foreclosure and you walk away with 10 grand, is that better than losing the house completely? 100%. So all of a sudden, our purchase price is I don't know if they owe 110. You see what I'm saying? I don't know if they owe 112. I don't know the exact number, but I just agreed to them that I would basically stop the foreclosure, pay off any underlying debt, and give them 10 grand. Okay. Sometimes I'll put in a little clause that says not to exceed a certain amount of money, right? I don't know the exact purchase price in that event. So under purchase price, I can also say see additional terms, and additional terms is on page 3, right? This little area right here is where you write in things that is specific to the transaction. So that's fun. When I figured that out when I was getting into this, I was like, holy crap, you can do anything. You can write in any term. You could whatever, anything specific to it, very unique to the transaction. It's all written in there under additional terms, which is really cool. So it kind of opens up a lot. Instead of you guys focusing on price, focus on the money they'd walk away with. Because if you go and try to talk to that same person, be like, look, I can give you 120 grand, right? Number one, they might say that's way too low. Or number two, they may be like, oh, you're going to give me 120 grand on top of what I owe the bank. Yes, I'll take that. It's like, no. You're going to get 10 grand. So it's like in those scenarios when you're working with a seller, try to figure out what they're hoping to walk away with. And I do the same thing when I'm working with agents. It's specifically around cash. It's like, well, what do they owe against the property? What are they hoping to walk away with? If you guys watched any of my live streams of me calling agents, that's what I did to get my creative deal. I talked to this agent. I'm like, well, what is he hoping to walk away with? Because if you guys have it listed for 320 or whatever, and after you minus fees out and stuff, like he's not going to walk away with much money, but like, what is he hoping to do? Right. And then we can work our way backwards on that. So in this particular case, it was a very specific purchase price because they already had their number in mind of what they would actually be netting at 172. So that's what we put here. But I want you guys to know it's not uncommon to not have a purchase price here, but just literally type in see additional term. Cool. So closing date on this one, May 14th. So we actually extended closing. It closes on Monday this coming week. So this is a cash deal. So a few things to note when it comes into the nitty-gritty stuff. So you can't come in here, and this is important. You can't come in here and start whiting out things and typing in more like different like verbiage and terminology into the pre-templated stuff. So contracts have been prepared by legal attorneys, right? And any document that has been prepared by some, attorney or whatever, law office, whatever you guys want to call it, you can't come in here and change something that they put together. Instead, you can only fill in the blanks and take what is here, right? If there is a change, like you need to maybe draw a line through one of these, things that are on the document. So I can't go do like a big whiteout and just like white out a whole section and then type in my own stuff. I can't do that. But what I can do is a couple things. I could, take a little draw. I could draw a line through if selected, whatever. I can draw a line through this whole entire section and redline it. And then I'd have to initial beside it. And so would the seller or the other party on the other side, they have to initial saying, hey, we agree that we're both, lining out this whole entire section. But I can't just change it on my own volition, right? Does that make sense, guys? I have to just either redline it out, draw initial beside it, or take what's there. I can only fill in the blanks and do that stuff, right? Because I'm not an acting attorney, don't have a law, don't have, a license or anything like that. Okay. So in this case, the first thing is like, what do they agree to leave at the property? And how I normally explain this part is like, hey, so what I normally say is I'll check others sometimes, and it's like, hey, look, anything that is here after May 14th and we close is mine. You can't come a week later after I close and say you left your washing machine, you left your dryer. You can't do that. I did this before, guys. It cost me almost $4,500 because we didn't check these boxes, and I didn't write that into our contract one time. And we did a deal here locally in Arizona, and the guy was like, "Oh my gosh, I left my my washer and dryer at the house. Can I go get it?" And it was been like 2 weeks, and the person that I sold the deal to already started demoing it, and that washer dryer was long gone. And he goes, "Well, you guys weren't, that wasn't in our contract. It was supposed to be my washer dryer." And we looked at the contract, and he was correct. So we had to pay the guy $4,500 to get him a new washer and dryer. Sucked. So very important that you draw that in and say, hey, and what that would actually look like is you check this little box other, and you say like in this, it says, the refrigerator, washer, dryer is actually included. What I do just to keep it simple oftentimes is just check this other box and say all personal property remaining in subject home after close of escrow shall convey, right? So any personal property left in the home after close of escrow shall convey, means it belongs to the new owner. Okay. So that's how you protect yourself there. All right. Next thing up. Can everybody read this agreement? Do I need to zoom in at all, or is this okay? Because I don't know how I'd zoom in, but I just want to make sure you guys can actually read this. Can everybody read it okay? Give me a yes in the chat if you can see this. All right. There we go. I'm just going to keep going, and I'll wait for you guys as yeses. Okay. So earnest money, or buyer shall deposit. Okay. Very important. We say shall deposit earnest money with the escrow agent. The earnest money shall be held by the escrow agent and credited toward the purchase price. At the close of escrow, if earnest money shall be deposited, it shall be deposited within 48 hours of accepted contract. So we have 48 hours to drop our earnest money. And this is just boilerplated, templated. If I want to throw any additional terms on this, and this is an important note, if you guys write in any additional terms later on in the contract, if there is a conflict between the additional terms and the conditions on any other term condition on this contract, then the additional terms conditions shall control. So basically, your contract can contradict itself. I could say up here it should be deposited within 48 hours of accepted terms, of accepted contract. And in my additional terms, I could say earnest money to be deposited after inspection period. And that is what controls, not what's actually up here. Okay. So that's an important note. So if I ever want to, and I recommend this to you guys, by the way, if you're going to be depositing earnest money, something I've really been pushing more towards here recently is making the earnest money due at the end of your inspection period, right? Because otherwise, like, you're depositing the earnest money, and then if you have to cancel, you got to get your earnest money back. And it's like, what's the point? You might as well just deposit the earnest money at the end of your inspection period. Okay. So, and you can write that into your additional terms. Does everybody follow me? Does that make sense? I want to make sure you guys can see the contract. You guys can read it. You're following along. Give me a yes in the chat if this makes sense. Cool. All right. Next, close of escrow. Close of escrow shall occur when the deed is recorded at the appropriate county recorder's office, right? If close of escrow does not occur on closing date through no fault of the buyer, the parties agree that closing date will automatically extend on a weekly basis at the option of the buyer to allow sufficient time to close for the close of escrow. There are no financing, homeowners association, or appraisal contingencies, right? And likewise, seller shall pay any cost necessary to convey fee simple, marketable, and insurable title to buyer, clear of all liens, mortgages, and all other encumbrances. Okay? So what that means, if they ever ask, is like, number one, oftentimes closing dates in real estate are treated like a nice goal, right? Oh, that's a good target. How often do deals actually close on time? I would say less than 50% of the time do deals actually close on the closing date, right? I feel like title companies wait 3 days before closing to actually start working on the file. But, this is investment property, so I understand their side too. It's like, hey, we don't know if you're actually going to proceed with the purchase or not. So nonetheless, it is the seller's responsibility to convey fee simple, marketable, and insurable title to buyer. What that means, fee simple is the best type of ownership you can have. That means you have all rights to the property, you have air rights, you have land rights, and all improvements on the land. You have full rights to the property, right? And that's what we believe we are buying. We need fee simple ownership. Like, for example, if you're buying a mobile home inside of a mobile home park where they just rent the land, you don't get fee simple title. Okay. That's not a thing. So what we are understanding when we're purchasing a piece of real estate, okay, we're not buying a mobile home. This is basically like buying an RV. When we're buying a piece of real estate, we need fee simple title. It means it's clean of all liens. There's no clouds on title, all that good stuff. Because insurable title is basically the title company. This is the whole function of a title company in general. Their whole function is to make sure that the property that they are facilitating the transaction for between you and the seller is clear, right? They say, look, we did all our title search. There's nobody that come make a claim against this property. When you give this person your money to purchase this, they have full right to sell this, and you will own this with fee simple title. Okay. There's no clouds on it. There's no memorandums. There's no weird liens that's going to pop up. No prior heirs or, people who could have, content that they said that they had rights to the property, anything like that. So that's what title companies are there for. They provide insurance to make sure that doesn't happen. So that's why it's important to get title insurance, because, in the event that something does come back later on down the road, you want to be able to make a claim against your insurance and say, hey guys, well, you said that this was clear. So especially in creative transactions, title insurance is very important, because all kind of stuff can pop up. I'll talk about that whenever we get to the creative contract, but that's what that section means. Okay. So it is important that they clear all liens, mortgages, and encumbrances. So normally this happens, and this is the great thing about cash. Normally, when you negotiate a cash deal, the money that goes to the seller is less the mortgage, less the liens and all that stuff. So if you tell them you're going to give them $200 and they owe $110 to the mortgage, They had a tax lien on the property for 20 grand. They didn't pay their, I don't know, they had somebody come work on the garage and they didn't pay them, so they put a lien on the house for 7 grand. All that stuff gets paid off, and whatever's left goes to the seller. Okay, so that way you get a clear title when you go to purchase the home. Okay, so that's how that works, and that's what that's what that section states. Okay, next, section 4, as is purchase. The property is being purchased as is in the condition that exists in the contract date. At the option of the buyer, any material changes to the property prior to the close of escrow will terminate this contract. So if someone decides to burn the house down between the time I got the contract to the time we go to close, I can terminate the contract. I don't have to buy it. If anything changes from the current condition that it's in at this moment, I can terminate my agreement. Okay, I'm buying it as is, where is today, in today's condition. If anything happens between now and closing, that I could terminate the contract. Okay, buyer shall have 10 business days unless otherwise stated, from the contract date to further inspect the property, and may cancel this contract within buyer's sole discretion for any reason during this inspection period. If so canceled, the buyer shall receive a refund of any earnest money paid. Okay, so we do 10 business days. So if I sign a contract on a Saturday, my inspection period technically doesn't even start till Monday, and I have over 2 weeks to get the property inspected. Now, when you're working with agents and you're doing cash deals, it's not uncommon to do 5 business days. Okay, it's not uncommon to do 3 business days, because a lot of times when agents are going to be doing this deal and getting you a great, cash number with their client off market, they're going to want a low inspection period. So it's okay to have a 3 business day, but just know this deal has to sell within 3 business days if you're wholesaling, or else you need to get out of there. Okay, you need to get out. Very important. So that's the as is purchase. Risk of loss. If there's any loss or damage to the property between contract date and closing date through no fault of the buyer, the risk of loss shall be on seller, right? So if the house burns down between now and the time we close, not on me, it's on the seller. The seller will have to make a homeowner's insurance claim or whatever, right? That loss is on the seller because I don't own the property. If the cost to repair any such loss or damage exceeds 10% of the purchase price, then either party may elect to cancel this contract without any further recourse. If so canceled, the buyer shall receive a refund of earnest money paid. So something happens to the property and it's going to cost them more than 20 grand to fix. In any event, I also have this other statement. If anything changes, I can cancel anyways. So risk of loss kind of states the same thing. Okay. Seller representations. Seller represents warrants and covenants as follows, all of which survive the close of escrow. The seller is not aware of any unrecorded liens, leases, or other encumbrances affecting the property. Right? If they know these things, they need to disclose these things, right? And the great thing about us working with agents is most of the time they have to disclose this stuff to their agent anyways. There's something called an SP, and I'll put it here in the chat, SPDS document. And you want to ask for this, okay? You want to ask for this whenever you're working with the agent and you're getting ready to potentially put in a contract. You want to ask for, it's called the SPUDS, even though there's no U in there. It's called a SPUDS document. And SPDS stands for Seller Property Disclosure Statement. So anything that they know about the property, they put on one document and they disclose it, okay? It is their responsibility to disclose it. They knew something and they did not disclose it, then they could be liable down the line for a lawsuit, okay? Very important. Next up, seller has not previously transferred or conveyed the property and shall not transfer or convey the property to any other person or entity prior to closing date. Seller understands that any subsequent offer accepted by seller must be a backup offer contingent on the cancellation of this contract. So if they say, yeah, I got a better offer, Matt, we're just going to be going forward with them. It's like, oh, interesting. Well, section 6, letter B there, you see where it says that you understand that any subsequent offer that you may accept has to be a backup contingent on the cancellation of this one. And we're not canceling. So thank you so much, right? That's in a nice way. And what happens oftentimes, guys, is you'll have people who want to not do what they say they're going to do. So you can make it to where they either sell it to you or they don't sell it at all. So we'll talk about that here in a second too. All right. Next up, let's see here. Seller has the actual authority to sell the property without the joinder or approval of any other person. So they actually have the right to sell the property. Pretty straightforward. Buyer disclosures. The following disclosures selected are applicable. If the property is constructed prior to 1978, the buyer agrees to obtain the disclosure pamphlet on protect your family from lead in your home, which you can get from the EPA.gov, which is just lead-based paint addendum, basically. Understanding that there could be lead-based paint in the home if it was built prior to 1978. Okay. Next, buyer or his members, Matthew Beard, is a licensed real estate agent in the state of Arizona. Buyer and or his members is not acting as a real estate agent in this transaction, but only as principal. So I'm not running this through my brokerage. And again, this property is in the state of Texas, but I do have to disclose that I do have a license. If you don't have a license, then you won't check this box and you won't fill this in. But if you do have a real estate license, you have to disclose that. Okay, so that's what that box is for. Everybody follow me here? We cool? Good up to this point? Any questions up to this point from what we discussed? If you got any questions, please put it in the chat. Okay. Again, this is the cash contract. This is just our 3-pager. Pretty straightforward stuff. All right. Next up, discount. We have to disclose that we're buying this property at a discount. So the seller acknowledges that the buyer is an investor that buys and sells real property for a profit. The purchase price does not necessarily represent the fair market value. So you understand, I'm not paying you retail for this property. I'm buying it to turn a profit, right? And normally everybody say, yep, totally makes sense. So I'm not like telling somebody like, oh, well, your house is actually only worth 200. Like this is retail, right? I mean, that could be a whole, I don't even know the word for that, but that could be a whole problem in and of itself. If you are basically lying, you can imagine like before Zillow, before Realtor.com, like before all these online sources to figure out what your house is worth, this probably happened quite a bit where somebody had more information than the selling party and they convinced them that this is just what their house is worth, right? Based on, the information they had provided. Well, it's pretty tough to do that nowadays. People can just Google their home and see what their Zestimate is and have a decent idea, but they understand we're buying at a discount. So we disclose that. All right. Now, notice to cure. This is a big one. We have this in all of our contracts, and this is so important here, the notice to cure, because oftentimes, I won't say oftentimes, but it happens quite a bit where you're unable to close at the closing date. Let's say your buyer backs out last minute. Okay. Let's just say you're buying the property and the funding falls through a day before closing and you need to be able to extend. Well, you need to extend from your own fault. So the title, it won't automatically extend. So in the event you can't perform, the seller has to cure you, right? And likewise, if the seller doesn't go in and sign their documents to sign to close, you can cure them. And basically what that means is if a party fails to comply with any provision of this contract, the other party shall deliver a notice to the non-complying party specifying the non-compliance, saying, hey, we were set to close and you did not close. If the non-compliance is not cured within 3 days after delivery of such notice, the failure to comply shall constitute a breach of this contract. Notwithstanding the foregoing, buyer is not required to provide any notice to seller if seller refuses and or otherwise states an intention to refuse to close escrow on or before the closing date, right? So if they refuse it, I technically don't have to cure them. I can go ahead and proceed with saying, hey, well, we can sue you if you don't close this property, right? This is a breach of contract at this point. But we do have this in there. A 3-day cure notice is important. It's a very important part of a real estate transaction because, again, very often do contracts not close on time, right? And you want to be able to have provisions to make sure people have repercussions if they don't close, right, for non-compliance. So that's what cure is. Basically, you send a notice to them, and when they get it in the mail, they got 3 days to comply. Otherwise, it's a breach of contract. So 10, breach. If the buyer breaches the contract, actual damages to the seller will be difficult to calculate. As such, buyer and seller agree that earnest money is reasonable approximation for any damages. And if the buyer breaches the contract, the seller's sole remember shall be limited to the buyer's earnest money, right? So assignment. Buyer has unqualified right to assign its rights under this contract to a third party. No notice to the seller of an assignment is necessary. So again, guys, we're doing these deals under the presumption that assigning is legal in the state that you are doing these contracts. Now with the rules and legislation in South Carolina, you probably don't want to use this or do these types of transactions in South Carolina anymore until kind of the dust settles and figure out what really needs to happen as far as like, okay, well, if you can't assign and you have to have a real estate license and you can't market properties until you take full legal ownership, that's a whole nother thing, right? But we're using these contracts in places where assigning is legal to do, okay? And we don't have to give notice to do so, right? Entire agreement. This contract contains the entire understanding between the parties concerning subject matter and supersedes any prior agreements and understandings, whether oral or written. So if we wrote a piece of paper and said, I'll sell you my house, and I had said, hey, Matt, I'll sell you my house orally, all that is superseded by this agreement now. We now have something in writing. Okay, severability. If any provision of this contract is determined to be invalid or unenforceable, such provision shall be severed and shall be inoperative. The remainder of this contract shall remain operative and binding to all parties. So if something is just like weird, being like, well, the seller has the third day of the month to do X, Y, and Z, like some very specific term that it just is deemed to be like, yeah, this doesn't make sense, or actually you can't really enforce this, then it's severed from the contract. Okay. But everything else still is, the whole contract isn't severed, just that one thing, right? Whatever is deemed to be unenforceable. Okay. And this is going to be very important to just read through, guys. Get familiar with the verbiage in this. I'm not an attorney, I didn't go to law school, but just like read it and be like, okay, this makes sense. So then you can explain it in layman terms to your prospect on the other side of the table or the agent involved. Okay. Lastly, the last page is probably the most important page of this whole thing. Waiver, no provision of this contract shall be deemed waived unless in writing. So if something needs to be changed, it has to be in writing and agreed on all parties. Jurisdiction, the contract shall be construed and interpreted in accordance with laws in the state of, and that'll be Texas there, and any action to enforce the terms of this contract must be brought to the state of Texas. Attorney fees, the prevailing party in any dispute or claim between buyer and seller arising out of our relating to this contract shall be awarded their reasonable attorney fees and costs. So if anyone needs to get an attorney to enforce this contract to get this done, then the person who is non-compliant will have to pay those fees. Okay. Counterparts. This contract may be executed in counterpart. All such counterparts constitute one. So basically, there's 3 pages to this thing. So if it ever gets like split up or something, it's like, hey, we understand this is actually 3 pages of this agreement. And then lastly, everybody, we made it here to the additional terms. This is the most important part of the contract. This is my favorite part of the contract. This is where you write in any weird terms or anything specific to the transaction. So if I promised the seller I was going to get him a dog, I would write it in here. If I said, in this case, you see, buyer and seller agree that title should hold back $5,000 of the purchase price, seller proceeds, to be released immediately and without further condition when seller vacates the property and turns over keys and access at the end of their 7-day post-occupancy ending 11:59 p.m. on May 21st, 2024, or before if they are out sooner. So this has a post-possession, and this has what's called an escrow holdback. So we write those kind of terms here in the additional terms. If there's a specific number, like I told you guys earlier, if there's a specific number that I told the seller that they was going to get after I paid off their liens, like in foreclosure, then I'd write it in here. If I said, hey, do you guys need, is it important that you close and be able to stay here a little bit so you can get your things together and then move on to your next place? And they'll probably say, yeah. So, okay, well, great. Well, this is how we do that. That's called, post occupancy, or that's called post possession. And what we'd have to do is like, do you think like a week or 2 weeks is enough? Like, what are you thinking? Oh, well, I mean, if we have like 2 weeks, that'd be great. Or 30 days would be even better. So, okay, well, honestly, like I could probably do 2 weeks. And what that would actually look like is we'll give you all your proceeds minus a little bit, right? Because we have to protect ourselves. There's been people who wouldn't leave at the end of their 2 weeks. There's been people who put holes in the walls and all kind of stuff before they left. It gets a little crazy sometimes. So in order to protect ourselves, we hold a little bit back at title. That money is yours. As soon as you vacate, it can be on or before that 14 days, or in this case, 7 days, you'll get that money. But you just got to let me know when you're gone. Like you can literally send me a text. Hey, Matt, I'm out of here. Here's the keys. Drop them off here. Thank you so much. We message title, and then title drops that off. So it's not like I'm holding the money. Escrow, the company, the people that are processing this transaction, they hold the money. Okay. And if you stay past your 14 days, there's a per diem charge. It's like $250 a day, which comes out of that $5,000. So you want to make sure that you're out of here before then. Okay. So all that specific to the transaction is drawn up in the additional terms. And then, of course, we sign off, and there is the agreement in whole. Does that make sense, everybody? What questions do we have on the cash contract before we move over to the creative one? What questions do you guys have on this? A lot of these terms are going to be also found in the creative contract, but I want to kind of show you guys how this works out and how it all gets put together. Any questions on the cash? So as you go to explain this, saying, I like to say, hey, let's see, what verbiage will we put for foreclosure if we are getting them more money than what is owed to the mortgage company? Well, you'll simply just say, buyer agrees to pay off liens estimated to be X amount of money and seller to net X amount at close of escrow, not to exceed a certain amount of money. So in the example that I gave you, let's just say they owe 110 approximately, and that's what we're working off of. And they agreed to saying, hey, 10 grand would be amazing if I can walk away with that. Then I would say buyer agrees to pay off all underlying debt estimated to be $110,000. Seller to net $10,000 at close of escrow. Total price between the two not to exceed $120,000. Because what could happen is that 110 is actually 113 or 114, right? So your purchase price would go from 120 to 124, 125. Sometimes it can go to 136. Who knows, right? So you want to put that not to exceed clause, because if it comes back more, then maybe you need to have a conversation with the seller and saying, hey, look, that 110 was actually 118. I know we agreed to give you 10, but that was under the presumption that it was 110. Does that make sense? So you just write that in there in additional terms. Okay, so that way you protect yourselves, because otherwise your purchase price could be super variable. It could go crazy high, and you're banking on 120, and after everything comes back, you're actually paying 136 or 140. So that changes a lot. So you want to write it in like that. Ruben says, will the agent be okay using this cash? 100%. 100%. If they want to draw up their own, cool. If they want us to give them an offer in writing, cool. This is the offer we used for the lady in Texas, right? She's an agent, and this is the agreement we used. So yeah. And I would just say, just being confident, you guys. So I'm going to give you this template. Just look over it. Go through it a few times. Get confident in the pitch. Get confident in the verbiage in here. Understanding that the variables are like your inspection period can be changed. Obviously what conveys with the property can be changed. And then, of course, the additional terms, whatever is specific to the transaction, you can write it in here. Okay. So let me share the creative contract. Let's pull it up. All right. Was that helpful, guys? Let's take a look. Okay. So I'm going to exit out of here. Give everybody just 1 second. Put it all together here. Wonderful. All right. So this is the contract that I got during my live calling sessions up to this point. Okay. So this is the creative deal that I did in Atlanta that actually cash flows really well. It's a nice property. So the creative contract is obviously a lot longer. It's 20 pages, as we have everything in here, because we actually included the sub 2 addendum as well. So it looks like this: seller disclosures and warranties and all this good stuff for the subject to addendum to purchase contract. So I'll break all this down the best I possibly can. A lot of this stuff, guys, on the creative side, I recommend you just getting a TC in the beginning. So then that way they can help. Of course, I want you to understand how to fill this stuff out, but I want you to have a TC to make sure that you have all your I's dotted and T's crossed. Okay? Because there's more components, obviously, to a creative transaction, because you're having to disclose when you're buying a property either on seller finance. Okay? Seller finance means they don't owe any money, or they're financing you their equity to buy their home, or subject to, meaning you're taking over their mortgage payments, subject to, right? So, and then of course you have hybrid deals. So I'm going to show you how this is all lined up here in the contract. So pretty straightforward. Where do we get a TC? If you email Sarah@mainplacehomes.com. We have a company called Deal Nanny this is what we do. We do TC on creative files and cash files. Okay. So here's the creative contract. And this is the reason why we don't provide this contract. This is, again, something that I don't have rights to sell, but again, this is the contract we'll actually fill out for you in our TC services. So first things first, on this page is basically just lining out the address of the property, the APN. If you have batch leads, you can actually look at the property details and you can get the APN number online. Obviously the county, legal description, just put to be provided by the escrow officer. Not that big of a deal. Yep, we do the entire US. Okay. And yes, to be provided by escrow agent. So leave that there. This kind of comes templated. We don't want to go like the legal description can be like a paragraph long sometimes. The real property is bearing the street address, section 1.1 up here, an APN section 1.2, and the legal description 1.3, together with all improvement fixtures and appurtenances thereon and incidental thereto, plus personal property described in section 1.1. So that's basically what we're saying, like, hey, we're purchasing the property, and the property constitutes everything that is there, right? And what we agree on that you're going to leave there in 1.12. All right. So as you can see in a creative contract, very oftentimes I'm not giving them a specific price. So they had this property listed for $340,000. Okay. I'm not buying it for $340,000. Instead, again, I told you guys how I like to work is I like to say, hey, well, what are you guys hoping to walk away with? And I work my way backwards based on what they're hoping to walk away with. Right. So knowing, because it would do me no justice to just put $340,000. In fact, I'd spend more money. I'd have to pay more money to buy houses if I did it that way. So instead, I try to figure out like, all right, well, is there a mortgage in place? Yes, there is. Great. Well, in order for me to give you an offer, I need to know how much that mortgage is. What's the balance on that mortgage? Okay. So in this case, the balance is $279,300. Okay. Well, that goes right here. Approximate existing first mortgage, buyer purchasing subject to. This is approximate. It could be $279,313.50, like whatever. But this is approximate, and understand it's approximate. The real numbers will be on the settlement statement given to you by the title company. Earnest money, like I said, I always do about $500. This is applied to the cash to seller, because what we focus on when we buy these deals is the money I got to give to the seller for me to take over their mortgage payments on a subject to, and the money I got to give to the agent. This $500 is applied to the money I got to give to the seller. Okay. So in this event here, you can see $6,500 is going to go to the commission of the agent, because there's not a second position loan. If there was, I'd put it here. If I'm getting a new loan, I'd put it here. If they have a seller carryback they're financing me, and that's a hybrid deal, I'd put it here. So oftentimes you'll see deals that it's like, hey, they want to sell for $300, but they have $80K in equity. You can't give them $80,000 on a sub 2 deal. It would never sell. It's not a good deal. So you have to do a hybrid deal where you take over the mortgage and you give them a little money down at close, and then the rest of the money that they have in their property, you're going to ask them to finance it to you. So maybe that's like $40,000 and you're giving them a monthly payment of $150, whatever. That number is put right here in the contract, whatever number they're carrying back. Okay. If it's a straight seller carryback and there is no sub 2, we just put the number there, right? They're saying their seller financing me $280,000. Okay. Amount to cure loan defaults. If they're behind on anything, it would go here. So oftentimes, like if I'm working with a foreclosure, guys, and I want to buy a foreclosure home subject to, well, I know I'm going to have to pay off some arrears. So if I say, look, I'll come to the table with $28,000, but guess what? They owe $21,000 in arrears. Cash at close of escrow is not $28,000 here. In fact, it's $21,000 goes to cure defaults, and then $7,000 will be down here. Does that make sense? I want you to think about this as like a ledger. You know, like on a spreadsheet, it's like this plus this plus this plus this plus this equals your total purchase price. It's like everything just kind of gets added up here. But it's line itemed out so everybody can understand what is what. And it's pretty straightforward. It's just like, hey, what, like each individual piece that goes into this purchase is going to be line itemed out. So if there's seller carryback financing, great, it goes there. If there's anything to cure defaults, it goes there. In this case, there was none. Okay. The only thing I had to negotiate was I'm going to be paying the agent's commission, okay, to them, $6,500. And then I'm coming to the table with $28,000. And we made a small mistake on this contract because this $500 should have been applied to this $28,000. So that'll just be an addendum, which I believe we already signed off on. So it's really $27,500 is the cash that I need to bring at close of escrow, which is this, because I've already put the $500 earnest money in. Does that make sense, everybody? Cool. So the close of escrow on this deal is May 22nd, which is, what is that, next week? So this will close next week. Let's go. You can see where she struck out. We put 30 days after effective date. She struck that out. We initial beside it, and we put May 22nd, 2024. So we're going to get this done. Our escrow agent in the Atlanta area, Wiseman Law, McDonough. So if you guys are doing creative deals in Atlanta, it's the first deal I'm going through Wiseman Law. So I'll let you guys know how it goes. But basically, this section is where you put the escrow agent or the title company or your closing attorney, whoever, and their contact information. Okay, so that's where that is. Done. Easy peasy. If there's an HOA, I'd put the name of the HOA and the amount here, that, you know, anything that I need to know in regards to the HOA. Parties, the seller, this is David, this is the seller's name, this is the address, and this is his email. This is my buying entity. This is my business address, and this is my business email address. Okay, all pretty straightforward. This page is basically just contact information. Page 3. All right. Inspection period. You guys, I told you that oftentimes with agent deals, you're not going to get 10 business days. This one, we had 3 business days. And I really didn't need any inspection because the house is moving ready. It's turnkey. This is not a cash deal. This is a creative deal. So I knew like, hey, I'm going to be buying it with these terms, even if it needs work. That's really on me. Okay. And then this section is kind of where, again, so guys, this whole document was drawn up by Sean St. Clair. If you wanted to buy these contracts to use for yourself, they're 10 grand for the packet. So kind of steep, but he will actually sell these to you if you are interested in buying them. But 10 grand is also pretty steep for some paperwork. So again, if you wanted to get access to this to do your creative deals, just use us as TC and we'll do it for you. Okay. So specific closing costs to be paid as followed. Okay. And this is where you really sell it to the seller or the seller's agent. You're letting them know like, hey, escrow fees and costs, 100% by buyer. I'm paying all that. Owner's title policy, 100% by buyer. I'm paying that. HOA transfer fees, I'm paying it. HOA capital improvement or reserve fees, I'm paying it. HOA disclosure fees, if there is one, I'm paying it. Closing fees of to be determined if closing at law firm, not through escrow agent. Like that's up to me. I don't know how much it's going to be, but that is up to me to pay. All right. So that's important. We sell it. Now remember in the first page, it said what constitutes the property. Personal property to be included in the sale includes all items set forth in section 2 and the following. Any personal items remaining in the property after close of escrow will convey. Just like I told you guys in the cash contract, this is where this goes on the creative contract. Okay. You don't want to get caught with somebody who had a washer and dryer that you did not put on the contract that you did then need to pay after you close like I did. And it costs $4,500. This is where you put it in there to make sure it conveys with you. Okay. Saying, hey, if it's there, it is yours. All right. Next up is addendums and acknowledgments. These are attached to the agreement. So you have a subject to addendum. It's attached to this agreement, and a seller acknowledgments. It's attached to this agreement. Okay. Oftentimes the seller acknowledgments is just executed at close of escrow. So sometimes we don't actually put it on the contract. Now, the subject to addendum can be a little scary, so we try to like at least get this done up front. So if there's any objections, we can handle it up front. Because this basically states like, hey, the mortgage is staying with you and you are still liable for this mortgage. No matter what I tell you, this mortgage is still in your name and you are liable for this. Okay, important. If there's seller carryback financing, the specific terms of that seller carryback will be put in section 1.13. So if I said, hey, you're going to finance me $200,000 to buy this house, or let's just imagine this 279 up here was not from the mortgage company, it was 279 seller carryback financing. Well, that 279 would go here, right? Buyer will pay seller $279,300 in monthly installments for a blank term. Installment payments of blah, blah, blah dollars will be paid to the seller for a number of payments. And if there's a balloon, then you'd write in on payment 120 if it's a 10-year balloon. Buyer here within to pay seller one lump sum payment of the remaining act. So basically you just line out your specific terms because these terms would be put on a note. Okay. So on a seller finance deal, the seller gives you a note. It's called a promissory note where it just lines out the specific terms. Let me show you an example of what a note looks like. So if they agree to do a seller finance, they put their terms on something that looks like this. Okay. So this is a note. This is a note for one of my own properties, right? So here, note secured by a deed of trust. All right. Here's the note itself. Here's my company. The property is sold, assigned to transfers. They have a due on sale clause. Here's the installment. So like all this information that gets put on the note, okay? All the information that gets put on the note comes from that section in the contract. So it's important that you have that in there because it instructs the title agent like how to actually fill out the note. But that is just a basic template. I wanted to have that ready for you guys to look at. Okay, any additional terms? The property will be transferred subject to the following liens and encumbrances. List all deeds of trust, mortgages, HOA dues owed, and other liens. So approximate existing first mortgage, seller's monthly mortgage statement, and copy of lender's note to be provided. We understand that this is what we're buying based on this, right? Will be transferred to these subject to the existing first mortgage. So, and then also the big piece, just like I told you guys on the last part of that contract, on the cash contract, page 3, where you write in additional terms on the creative contract. Okay. So by the way, I didn't want to skip this over. If they had a reinstatement, you'd put in that reinstatement amount here, right? But the additional terms on the creative contract can actually be found in section 1.14 under other. So you check the little box that says other, and it says buyer to purchase the home subject to the existing mortgage. These numbers reflected on this agreement are based on the understanding that there are no other liens other than the mortgage, back taxes, or anything else that would affect the total debt that is stated here. Okay. If I had post possession or anything else or anything weird, I write it all in here under the other statement section. If I needed to like write in more stuff, I could create an addendum and say, see addendum 1 point whatever below. And I could create a whole page of just lines and write in more stuff. And I could put that here in the contract. Okay. Occupancy 1.15. There are no parties in occupancy of the property other than the seller. Buyer will be given occupancy of the property at closing, otherwise stated specified herein. Blah. Or like if there's tenants in place, I'd check that off, right? And if there are tenants in place, then I need an executed lease. I need the rent rolls. I need the tenant information. There would be a tenant information form that they would fill out later, so I can get all that back from them. That's no big deal. Okay. Now we kind of get into the boilerplated stuff. So the pieces of this contract that you'd actually fill out specific to like the actual transaction and the person you're working with is leading all up here to 1.15. Like all this stuff is just specific to the transaction. All this stuff right here. After that, you kind of get into your boilerplated verbiage, right? The personal property be conveyed as part of the property includes, but is not limited to, built-in appliances, ceiling fans, remote controls, operate any fixtures, blah, blah, blah. So like this is basically just describes like what is included in the property other than whatever we didn't mention above, which we said any personal property remaining will convey. So that's what this section is for. Drapery rods, wall mounted TV brackets, all this stuff. Purchase price, method of payment. The purchase price shall be paid by buyer pursuant to the provisions in 1.5. So that was already addressed up here. Okay. Status of title documents as soon as practical following the effective date of this contract. Escrow agent shall cause to be issued and delivered to buyer a current commitment for an Alta residential owner's policy of title insurance, a title report basically, and copies of all documents referred as requirements and exemptions therein, together with the title report. So if there's any exceptions on the title report, which basically, guys, if there's any exceptions on the title report, that's saying like, hey, this title is clear except for this thing over here that we need to go do some further research on, right? Like, hey, the title looks good, and here's an exception because it looks like they paid something over here that we need to go verify, or hey, there's this other seller named Matt Beard. We don't think it's the same person you're buying the house from, but we need to go get that cleared, right? You would have exceptions on a title report that needs to get cleared before they can close and provide title insurance. Does that make sense? So that basically states that. Okay. Yay. Fun. 4.2, buyers review a title. Buyers shall have 10 days from receipt of the title documents from any amendments thereto to provide seller with any notice of items shown on the title document. So as soon as I get the title report back, I got 10 days to take that to the seller and be like, hey, what's going on over here? We need to clear this title report, right? Seller's spouse to execute contract or deed. If seller is married and the spouse has not executed this contract, seller's spouse shall execute this contract or execute and deliver a deed for the property to the escrow agent within 3 days from this effective date. So they have a spouse, we need to get them to sign within 3 days. Okay. If they have a septic, here's that. If they have lead-based paint, here's that. 1978 or older, we get a lead-based paint addendum or acquire that pamphlet for lead-based paint. If the residence was structured prior to 1978, you initial here. If it was later, you initial here. Pretty straightforward. Changes to the property prior to close of escrow, just like in the cash contract, we address it here. Seller shall provide notice to the buyer within 3 days of any material changes to the property. Buyer shall have 5 days from buyer's receipt of such notice to notify seller if buyer elects to cancel the contract and receive return or deposit, and the seller shall return to buyer any other items or things of value given to the buyer to seller. In the event insurance coverage or any other claim, right, or remedy is available for any material changes to the property prior to close of escrow, buyer elects to proceed to close of escrow. Seller shall assign any and all rights to any insurance proceeds, claims, rights, and remedies to the buyer on or before close of escrow. So basically, guys, if that property burns down or if there's a hailstorm and it ruins the roof, we can file an insurance claim, and any proceeds from the insurance claim shall go to us. In fact, I know a person in Texas that's what they do on all their transactions. Before they close, leading up to the close of escrow, as soon as they open escrow, they get somebody out, an insurance adjuster, to go walk the roof. And then they file a claim on the roof to get it replaced, even if it's very minimum damage. And they get a check at close of escrow for the repairs that are needed. And sometimes it's not even that drastic. They actually make money on doing the insurance claims. That's not what I do, but I know people that actually do that. So in the contract is drawn out to where you could do that if you need to, and the proceeds would go to you as lined out here in the contract. Okay. Inspection of property. Obviously, this is our inspection period. We do our due diligence, and that kind of line items that out. Buyers continue to access, like they have to give us access to the property from the effective date within reasonable time. Seller to keep and maintain utility service. So we need the power on, we need water on, so that way we can do our inspections and stuff like that. So it's their responsibility to maintain that leading up to close of escrow. Unless you like literally don't have power on, that can be agreed on by you and the seller being like, okay, I understand that you currently don't have power onto the property. All right, fine. Close of escrow. Seller and buyer engaged in escrow with an escrow agent to act as an escrow agent for the closing of the transaction. So obviously COE stands for a close of escrow. We know we're going to be closing with the title company or a closing attorney that was already line itemed out above in the contract. Buyer's closing deliveries, the amount due at close of escrow under section 1.5 shall be paid to seller by buyer through escrow. So we're not paying them outside of escrow. Everything is paid through escrow, the company that we're working with, people we're working with to close the transaction. Okay. Buyer's pro rata portion as of the close of escrow of all ad valorem real estate taxes. So ad valorem, guys, is just a Latin word for assessed value. Taxes are typically paid in arrears. So if a seller, all right, this is important. So how this would work is sometimes a seller will pay for their year taxes in advance. Okay. So if you're closing on a property in, in May, sometimes they have already paid their property taxes through the end of the year. Okay. So in the event that they did, well, then there's a pro rata portion, meaning that, hey, leading up to May is their own cost. But anything that they paid, May prorated all the way to the end of the year, will be a credit back to them. And it'll be your responsibility to pay that at close of escrow. Okay. An affidavit of property value is as required by state law. You can tell that we moved because we do all kind of states. We just literally put state law here and it doesn't even have the same font, whatever. All specific closing costs to be paid by buyer as set forth above. All of the documents escrow agent reasonably request the buyer to execute to effectuate the close of escrow. So we got to make sure that time is of the essence is a saying in real estate. It's not just being like, hey, you need to hurry up, time's of the essence. No, it's like an actual legal term saying, hey, you have to do your part to make sure we close on time. Otherwise, you could be in breach of contract if you are not doing your part. And then likewise, all the things the sellers need to deliver, right? They need to convey title. They need to execute the property value, affidavit of property value. They need to execute all documents. Seller should execute all of the documents escrow agent reasonably request. There's the tax proration we just discussed. Specific closing costs. The seller shall pay the specific closing cost applicable above. So normally we say we pay all of it, but if there is a box that we checked for the seller, then they understand they have to pay that. And then buyer right to proceed without an escrow agent. Sometimes in a creative file, guys, you won't have an escrow agent because it's an FHA file or a VA file and no one's willing to close. A title company isn't, and you need to hire like a closing attorney. So sometimes you won't have an escrow agent to process some of these files, and they need to understand if that is the event, then they sign off on that, right? Seller understands, acknowledges, and agrees that notwithstanding the fact that the seller may have paid a closing fee to a law firm or buyer choosing for the purpose of closing this transaction, the law firm represents the buyer only. So basically, if I choose the law firm to close this file, they represent me, and they understand they don't represent the seller, so they need to do their own due diligence. Okay, that's page 10. Representations, warranties, all the other stuff. Seller has full right to sell. Most of this stuff, again, very similar to what we went through in the cash contract. The liens and encumbrances are listed in the section above. If there's any that we're not, you need to make sure that we know. It's up to them. The seller shall indemnify, protect, defend, and hold harmless buyer for and from any and all costs, demands, and claims related to or associated with such unrecorded and undisclosed liens or encumbrances. So it's not the buyer's responsibility to know the liens that they may know about. It's their responsibility, and we are held harmless if we do not know about these things. Okay? Seller will maintain and repair the property so that as of close of escrow, it will be substantially the same conditions as the effective date. So the property is literally what we think it is today. So you got to keep up with it accordingly. The seller has disclosed to buyer all material latent defects. So that's the SPUDS document we talked about above. So the SPUDS. That's the seller property disclosure statement. So you want to ask for that again. Here it is. If you missed that, you want to ask for the SPUDS document. Okay. What's up, Anthony? Thanks for being here. The property improvements, buildings, structures, appliances, roof, plumbing, heating, blah, 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 is all in good working order. Normally that's addressed in the SPUDS documents anyways. The seller will deliver the property to buyer at close of escrow in broom clean condition. This is really like, meh, whatever. this rarely happens, honestly, but it's in there. Seller warrants that the foregoing representation, warranties, and covenants shall be true as of the date of this contract. So everything that I say is true as of the day that I sign this. If something weird pops up that I did not take into account for between now and close of escrow, like a lien or something, I'm letting you know right now everything that I know about, right? And that's what that warrants. Buyer representations and warranties. Buyer warrants that the buyer has a full right, power, and authority to enter into this contract, right? So I have the ability to sign for my company to say, I want to buy this house. Okay. And then just like in the cash contract, there's a cure period. So they can cure. Non-compliance is not cured within 10 days after receipt of cure notice. Failure to comply shall become a breach of contract. So you want to make sure you have that cure notice. Default by seller, if the seller shall breach any of the terms or provisions of this contract prior to close of escrow, buyer may proceed against the seller for any claim or remedy the buyer may have in law or equity, which includes but is not limited to specific performance and or damage. So I can literally sue somebody just for specific performance. Not really going after them for money, but saying, hey, I want you to do what I'm asking you to do. There's a default by buyer. If the buyer breaches the contract, seller accepts the deposit as the seller's sole right to damages. So whatever my earnest money is what they can claim for damages for me breaching the contract. Attorney fees, whoever has to hire an attorney to get someone to do what they say they're going to do, the party that has not done what they said they're going to do has to pay those fees. Okay. So no oral changes. That's pretty standard, right? Each party acknowledges everything that's in this agreement. Any and all notices, demands, and requests is required to be in writing. Okay. Has to be signed off by everybody. Miscellaneous, right? Here's the addendum. So acknowledgments and additional terms and conditions, all other addendums and provisions, acknowledgments marked in 1.13. So this is your subject to addendum. This is your seller acknowledgments addendum, right? Are deemed part of this contract. Assignment, buyer may assign this contract or any of its rights hereunder to a person, partnership, or corporation, or any other entity, and the seller's consent to such assignment is not necessary or required. Okay, so we have the right to assign, obviously in states where we can. Successors and assigns, the contract shall be binding upon and inure the benefit of the parties hereto and their respective successors and assigns. So whoever I assign this to is responsible to the contract that I have signed here with the seller. Okay. They're not adding any additional terms. Just what is in writing is what they are responsible to. Waiver, the waiver by any party hereto of any right granted to it hereunder shall be not deemed to be waiver or any other right granted. So basically, we're not adding anything to the contract. And again, kind of constitute the same thing up here, saying, hey, if we're going to make any changes, it needs to be in writing. Okay. Severability. So any provision of this contract is unenforceable, right? Or invalid, can be severed from the contract individually, just like in the cash contract. If there's something weird in here that just can't be enforced, that individual thing can be severed and not a part of this agreement, but everything else will survive. Okay, there you go. There's the saying, time is of the essence. Time is of the essence with respect to performance of all terms, conditions, and provisions of this contract. So you got to do your best to get the escrow agent back the information they asked for. Okay. Choice of law. This contract shall be governed and enforced by under the laws of the state which the property is located. Memorandum of contract. We file memorandums on our contracts, so you want to have this in here. So seller agrees that the buyer may execute, acknowledge, and record a memorandum of this contract in the form attached hereto. Exhibit B, if we want to give them the memorandum of contract to review. And in the event the buyer elects to execute, acknowledge, and record the memorandum of contract, the buyer shall execute, acknowledge, and deliver to the escrow agent a notice of termination and quitclaim deed of any interest in the property in the form of attached hereto. So basically what this says, guys, is I have the right to file a memorandum. I have to disclose to them, to the seller, if I'm going to file a memorandum. And if you guys don't know what a memorandum is, basically this says, hey, if you're going to sell the property, it's going to be to me and not to anyone else. So if you start acting weird, you ghost me, whatever, great. My memorandum clouds title. They can't close with my memorandum on file if they want title insurance. Okay, so that's important. So it's either I buy it or no one else does, or I give written consent that I allow someone to sell the property to someone else. I've had sellers do this before, guys, where, we were good on the price, we were good on terms, and the next thing you know, they ghost me, and I had my memorandum, and a year later, sometimes someone's like, hey, we're trying to close X, Y, and Z property. Matt, how are you? I'm like, I'm great. How are you? I said, well, we're trying to close, but we need you to release your memorandum. I'm like, well, I'm not going to do that unless you pay me, because this is how I feed my family. This is how I do business, and this person completely ghosted me. Can't make them sell me the house, but I can make sure that I control who buys it. And they're like, well, how much do you want? Plenty of times. I mean, I've gotten 10 grand before just to release my memorandum. So you file this to protect yourself because you never know what's going to happen. And in the event that you do release a memorandum, then it kind of gives the provisions here. Say, okay, we have to sign a notice of termination of your memorandum, and you give that to the title company and all that good stuff. Okay. So that's that section in the contract. Counterparts, this contract may be executed in different pieces, so it's all together. I mean, we're talking about a 20-page contract here, guys. And this is a voluntary agreement. The parties affirm, acknowledge, and agree that they are entering into this contract voluntarily and have not been threatened, coerced, intimidated, or any other pressure in any way pressured into signing this contract. They have had sufficient time to reflect upon the finality of this contract, and they have had sufficient opportunity to consult with legal, tax, and financial counsel regarding this contract. If such time has not been given, the parties by signing this contract waive any right to claim this contract is invalid under this provision. Okay, so you've had your time to think about it. You slept on it, and let's go, right? Subject to addendum, guys. I'm not even going to go through this because it's long and exhausting, but basically it's all the things in regards to how someone is liable for their underlying contract that we're buying subject to. Okay, so any kind of notice of change of address, I need like a limited power of attorney, seller servicing, seller shall execute an assignment of insurance proceeds in the favor of the buyer. So if I leave the insurance policy in place on the property that I purchased and the house burns down, I get the proceeds of that, not them, because I actually own the house. That's if I leave the insurance in place. So all those provisions that need to be signed off on by a seller when they sell their home right here: failure to make timely payments, no longer deduct mortgage interest, right? So basically the seller understands that and acknowledges and agrees that seller cannot deduct mortgage interest paid by buyer, even though the seller may continue to receive a Form 1098 for the existing loan. So they're not going to deduct that from their taxes because it's not them making the payments. We understand there's a due on sale clause. We understand that existing loans on the credit report. So the existing loan is going to stay on their credit report. In the event of foreclosure, seller understands, acknowledges, and agrees that in the event of existing loans are not paid, seller will be subject to a foreclosure proceeding, and such proceedings may harm seller's credit. They understand they have to sign off on all this. And this is the document that can be a little scary to sellers, but it's important, again, for them to sign this so they acknowledge all the things that could go wrong in a transaction like this. And this is the reason why they have to believe in you as the buyer, and also subject to has to solve a problem for them. It's the reason why it's not a good fit for everybody, because there are definitely risks involved. If I could only do seller finance deals, I would. Subject to is pretty risky, but you can still buy properties this way as long as everybody's on the same page. Because it's not what happens today, guys. It's not what happens tomorrow, not what happens next year. When you buy a home subject to, you're banking on things working out for 10 years. Okay. And you're also banking on the seller to be on the same page with you for 10 years. And I will say, sometimes sellers get a little weird when they sold you their home. So when I bought my home with me and my wife, like my first home I've ever purchased was subject to, well, that 2 years and the home appreciated 250 grand. The seller got a little weird. He's like, well, like who gets the equity now? And I'm like, I do. I bought the house, right? So that's just 2 years. So understand that everybody needs to be on the same page and everything needs to be communicated and disclosed up front. So there's no weird business down the road. And in the event they try to get the note called due because they get upset, they don't get the equity or whatever, or the upside, well, you're protected here and you can sue for damages. So that is the creative contract. What questions do we have on the creative contract? I'm going to share with you guys the one that I did for my personal house. I think this will be interesting for you guys. If you're in the mode of you want to buy a creative deal to move your family in, or if it's to be your next personal home, well, then this could be a great thing for you. So if you're in that mode, I got some yeses earlier. Who wants to buy their first home that they, or their next home personally on creative finance? I'm going to pull up the contract here. Let's see. Let's go. Woo, that was a mouthful too. Here we go. All right. So what you'll see is for this one, we used the traditional Arizona contract. The agent actually filled it out with the terms that they wanted. Let me double check. Yeah. Okay. Let's go. Okay. Ruben says, is it better to close a sub-2 seller finance transaction using a mirror wrap so the seller is 100% protected in the case of default? No. I mean, it doesn't really matter. They're still under the same, legal responsibility regardless. If you do a mirror wrap, your sellers are in second position. Let's go. Or does the performance clause take care of that? The performance clause really is unenforceable, to be honest with you. It doesn't really hold up in court. So if they want to be a little bit more protected, then sure, do a mirror wrap and they have a note and deed of trust where they're the lender, but still it was a subject to transaction. So they still have quite a bit of risk. So let's look at this. I'm gonna pull up 2307373. So the great thing about creative financing is that it is a skill. It is something that no one can really ever take away from you. Once you understand how to do these deals and how to put them together, like no one's going to be able to take this away. Like you can, for the rest of your life, you'll be able to buy homes just like this, whether that be your next personal property or for your portfolio, you'll always be able to do this. And, specifically on like what we talk about is like going out and finding these deals. It's as easy as pulling a list and starting having conversations. So my wife and I, we bought a house out in Queen Creek about 2.5 years ago. I had to put about $250,000 in renovations into the home, and it had just a bunch of land. And I quickly realized that I'm not a farmer. I don't want all the land, but I was going to deal with it. It was a really nice house. I bought it for $530. It's worth like $950 now, and I put $250,000 in. So it's not like I'm going to be making a killing on it, but it is what it is. But from then on, I was like, well, if we ever get another house, because again, we moved out of a house that I bought subject to, and I bought this one using traditional financing. And I was like, well, if I ever buy another house, it's definitely going to have to be how on the more creative side that I normally do. And again, once you understand how to put these deals together, you know what to look for and you know the pain that you want to solve. So I pulled a list and I'm like, well, a lot of times for the higher end price point, the people don't need the money at close because they have other businesses, they have other ways of making money. They don't need all their proceeds. In fact, they probably don't want all their proceeds for tax purposes. And then you have the other side of the equation of, okay, well, you also can work with people who have, very little equity. You can easily pull that list and you can take a shot and see what sticks. And I guarantee you'll probably find somebody who has low equity that'll be willing to sell their home to you subject to. But then it kind of comes down to affordability and getting good interest rates. So this particular property was an interesting one because my wife started going out and she started going to like open houses and stuff. And I'm normally like, look, you going to open houses, we got to buy this creative. So it's good to go look. But at the same time, I don't know if they're actually going to, the houses that you're going to go look at, don't know if they're going to be able to sell the house to us the way that we want to buy it, right? But it's also always just a conversation. Who knows, right? So if you're skeptical and you're like, well, I don't know if I'm going to be able to find my house that I want to move into like this, guys, right now is the time. Interest rates are going down. They're back in the sixes now for the first time in a long time. So these opportunities are going to become less and less and less. So if you're looking to buy your own personal home subject to, you need to do it right now. I promise you, there's going to be less deals to buy creatively in a year than they are today. So the time is now to do this stuff. But so she went out and she started looking at open houses and stuff. And I met with the agent on this one house that she really liked. And the agent was like, you're one of those wholesalers, aren't you? I'm like, well, I do wholesale, but I do buy and hold. I do a bunch of different things. And we started to have a conversation around this. And I don't think it was something that obviously was a plan A for them, but it was something that, hey, as the property continues to set, maybe they consider it. Okay. So this particular home that I ended up getting, my wife went to the open house and it actually worked out where they were open to hearing out options. The challenging part about this deal was that the seller only owed about $200,000 on the mortgage and is for sale for about $900,000. So he has roughly almost $700,000 in equity. And hybrid deals with that much equity is typically tough to put together unless they don't need the money right now. They'd actually prefer not to get all of it so they can see more of a return as the years to come. So it just so happened this guy owns a roofing company. He didn't need the money right now and he'd be willing to work something out. So I'll show you the house real fast and I'll kind of show you the address. I'll show you the contract. So here's the home that we got doing this. So basically it's a nice little house. It's on about a third of an acre. Again, we currently live on 1.3 acres. It's got a casita out front, just a nice clean house, nothing too crazy. It's pretty. It's got a nice backyard. If you guys don't know, I have a 4-year-old and a 1-year-old. So my 4-year-old really loved the outside of this house and my wife loved the fact that there's a bath in the shower. But but this is basically just like a really nice house. She's like, oh my gosh, this is perfect. This would be something great we can kind of grow into and be great for the family. The school district's nice and it's not as much land to have to manage. So I'm like, all right, well, if they're open to doing something creative, let's see if we can figure something out. And that's kind of how the conversations went. And it has like this little backyard playground set thing that he really loves. So you can get the house you're looking for and the kind of property you want on the terms that you need if you know how to put these deals together and have conversations is what I'm saying. So after we had some conversations and we went through a couple different options, and will it work or will it won't work? I don't know. Let's just talk about it. And it just so happened that they were willing to try to figure something out. We came to these agreements, to these terms. So the purchase price being $894,500, $10,000 earnest money, which is way more than I normally do. But since it's my own home, I did $10,000. I put it in. And then they were willing to finance their equity with basically a $90,000 down payment. So you see $10,000 and the $80,000. So $90,000 down, and he's financing the rest with a 15-year balloon on a move-in ready property. Crazy. The amount to be financed is $804,500. So again, $10,000 earnest, $80,000 down on the rest. And again, like if you don't have this kind of money, you could get private money to fund it if you're looking for that kind of deal. If you're like, hey, I want to save up to buy my own home subject to, like 100% you can do this stuff, guys. 10% entry is normally a little bit on the higher end of what I'd recommend. I normally do somewhere between 5 or 7%. But again, with the terms that he was willing to do and the amount of equity he was willing to carry, perfect. So $10,000 down, $80,000 was due as additional payment at close of escrow, which is June 7th. So we close here in like 3 weeks. And then, just like, hey, this is what's included in the sale, just like you guys saw in our contract. This is an Arizona realtor's contract. So I can't fill this one out. Well, I guess I can. I do have my license. But the agent filled this one out for us and basically lined out all of our terms. And just like our cash contract, there's 3 pages. Of course, it kind of goes over the same stuff. Buyer's warned for the homeowner. Sorry, for the home warranty plan, and is there a lead-based pane, and is there a sewer connection I sign off on, and all that other good stuff. And then it has additional terms, just like our contract does, right? Buyer is not represented. I waive the appraisal clause. I provide proof of funds. And buyer will be paying all seller's closing costs with the exception of listing agent commission. Beautiful. All right there. So it has just like what we have in our cash contract. So what I'm saying is agents are going to still be very privy to the kind of contract that I'm going to be giving you guys as the template, because this is what a typical agreement looks like anyways. There's always a section to write in additional terms. So it ended up being, so we got this back in April and, closing on June 7th. But what I'm saying here, guys, is that your limit is really just a limit you put on yourself. If you're in a place where you want to get your own creative deal, if you're in a place where you want to buy your own home on seller finance, go pull a list today. What kind of home are you looking for? What kind of payment can you afford? How much money can you put down? Okay, if you're not in a place where you can put any money down right now, then great. We need to do a couple of wholesale deals. Take that money from the wholesale deal and go buy your next house. Like, that's up to you. But ultimately, guys, like, you could pull a list right now in your area, and I guarantee there's somebody who'll be willing to hear you out. You can go the super low equity route. Now, the challenging part about going super low equity, like if I was in, Joanne, I know you're in like right there on the border, like in Reno, the border there in California. Like if I was just doing that area, I would draw that's where I wanted to buy. I draw my, Polygon search. And you know what? I'm going to do this for you guys right now. Hang on. I'm going to do this right now. I know we're getting off the subject a little bit, but I think it's important for this. Any questions on the contract stuff though, before I do this? Okay. If you guys have any questions, please put it in. But I'm going to give you guys the cash template once we wrap this up. But let's just say here in Batch Leads, I was going to Reno, right? So here we are, and I do a boundary search, and I kind of search the whole thing all the way down here to the south side of. I don't know if I'm going too far out, but Joanne, just let me know. But let's just say this is my area that I'd want to buy in. I can pull a couple different lists, and I can start reaching out to these agents, right? I would say, okay, well, give me all residential single family homes. We go single family that is active on market. Okay, it's been listed for at least 45 days. And let's just say like you want to buy a $600,000 home, or I don't know, 550 or something, whatever that is in your area. Let's do 550 max. Let's do like 450 to 5. Okay. And so that's 12 properties. And let's do ownership info as an individual, 6 properties. Valuation equity, let's say max 15%. Okay. So there's one property that fits that description. So let me try to expand this out a little bit. Let's go 350, let's go 250 to 7. Big range here. But that's 4 properties if we did that. So you got this really nice house off Starboard Drive in Verde, Nevada. Look at this thing. It's gorgeous. It's nice. Mr. James Boyle owns this property. He bought it with a VA loan for $680. He still owes 768, and he's trying to sell it for 719. Interest rate's 5.81. Not amazing, but you're gonna be living here. This is gonna be your house. It's a brand new house, basically. That I guarantee you call them. It may not be their first option, but to know that you'd actually be the person moving into it, I think they'd be willing to hear you out. And again, maybe it's not their first option, but you never know. It's a gorgeous house. Easy. Today, they don't even have that much equity. So like, look, if they were to sell this property at $719,900, you multiply that by 0.93, they would actually net, after paying closing costs and assuming they didn't have to do any repairs, they would net $669. And Batch says they owe $668. So maybe they walk away with $1,000. Maybe. That's crazy. That's crazy, right? And that's just one example. And then you can go to the other extreme, right? And you say, hey, look, I probably don't want to give anything more than like a 10% down payment. So give me everything that has like a minimum equity, or like maybe maximum equity of like 50%. So right there in the middle of the road. Okay, that's 16 properties. So these are hybrid deals, right? You can go about having a conversation with these people, and maybe they'd be okay with covering and leaving some equity in it and you giving them a monthly payment, right? Or you can go to the other extreme and say, hey, give everybody has minimum 85% equity. So it's almost free and clear. There's 5 properties right now that have been listed on market for at least 45 days that the owner almost owns it free and clear. Well, maybe they'd be open to doing the seller finance. Who knows? But those are just a few niche lists. You're talking about 25 properties. If your goal was to find a home that you can move into for creative finance and you had to market and prospect 25 properties, that's easy. You can do that this afternoon. You can do that in an hour. It's just a matter of putting some thought into the kind of property you're looking for. And I guarantee there's somebody out there who's willing to hear you out, especially in this market. It's only going to get more tough as the interest rates get better because these properties are going to sell a lot faster. But right now is a perfect time. He said, what terms did you get for the seller carryback beyond the 15-year balloon? So I had to pay the guy 6% interest on his seller financing portion, but the mortgage is 2.75. So the $200,000 portion of it is 2.75, and the rest, which is like roughly 600,000, is at 6%. So if you blend it together, it comes down into like the 5s. It's not wonderful, but it'll do, right? But a 15-year balloon on that is plenty. Like 15 years down the road, who knows if we're going to still be living in that house, probably moving to something else. But that's how you do it, guys. And for the rest of your life, like I'll probably never buy another home on just traditional terms and going through a lender. When you can go get the kind of house that you want and the kind of house you're looking for, doing stuff like this, like it's a no-brainer. But you can put all that in your contract. Again, guys, I'm here to help whatever you need. If you want to put together more creative deals, if you need help with TC, if you need help with whatever, we do these free trainings so you guys can do more deals. I want you to do deals. We want to help you with your transactions. We try to keep the book as open as possible, whatever we can do to help. But if you're in the mode, because I need to get you guys doing deals, because as you do deals, I want to help you scale that. And that's where like our mentorship program comes in. So if you need help like growing to the next level, then great. We should talk about it. I know some of you guys already have my Calendly link. If you don't have it, then I will post it here. But if you haven't done deals and you're in the mode of like just learning, I want to encourage you to get off the sidelines. If you want to talk more about your business, talk more about real estate in general, and see if we can be a good fit for the program because you're ready to scale your business, then we should use this Calendly link. The contracts for this, Mary Soul, you're going to be able to find it in the Masterclass Pass. So I'm going to take this recording here today. I'm going to download it. I'm going to put it in the Masterclass Pass, which is free. All that stuff is always free. So all of our trainings, I think this is our 11th Masterclass this week. Crazy. Thank you guys, by the way, for tuning in and being a part of this. You can go to Masterclass Pass. So it's noflufflive.com/masterclass. You go there, click that link. You'll enter your information. All these, it's like an online course, basically. You'll see all of our previous masterclasses and all the resources. So you get the recording from today and the cash contract that we went over for the template. So let's go. We're here to help you guys. Hey, thank you so much. What do you guys think about the contract masterclass? Ruben says, thank you. Appreciate it. You guys are amazing. Thank you. Thank you all for being here today on today's training. Hope you got some value. Hope you have an amazing Saturday. I'm going to be moving all weekend, so I got to go get to work. I appreciate you guys. We'll see you next time.